above
By
class
the
A
said
to
instrument. By the said instrument.
by the said instrument. My lord, court is referring to the instrument of accession signed by
the IOA, instrument of accession.
Sri Raghunath Rao, my lord, or maybe his my lord, ancestor. By the said instrument, the petitioner accepted the matter specified in the schedule thereto as matters with respect to which the Dominion legislature may make laws for the state, and declared his intent that the Governor General of India, the Dominion legislature, the federal court, and any other Dominion authority established for the purpose of Dominion shall, subject to terms of the instrument exercise in relation to Kurundwad state, such functions as may be vested in so and so, so and so, so and so of the instrument, provided that nothing therein shall be deemed to commit the ruler in any way to acceptance of any future constitution of India, or to fetter his discretion to enter into agreements with the government of India under any such future constitution. Subsequently, a number of rulers executed agreements of merger and transferred the administration of their states to the Dominion of India. The merger agreement was in the form given in the white paper on Indian states, and it was executed in so and so. They were not para 4.
You know, this one.
There's a little bit of a background about Kurundwad state.
Oh.
Kurundwad is a very small town, very close to Sangli. And Kurundwad is on the banks of the river Krishna. And there's a very famous, there's a place of pilgrimage called Narsobachi Wadi, where lots of pilgrims come from across the country. And once in a year, the Krishna will rise and sweep the whole town clean, you know. Because
the town clean.
And because the Krishna is very, and the lands are extremely fertile because of the Krishna river, right on the banks of the Krishna.
Maybe that may be the reason why the human habitation must have established there near
the sources of water and
yes.
All earlier
or earlier civilizations are on the bank of
the river.
Now your lordships may come to page 548, the arguments. The two constitutional provisions were dispensed with were repealed by way of a definition clause, not like unlike interpretation clause, Lord, here kindly bear one factor in mind. 370, sub-article 3, has an inbuilt extinguishing provision. 370 sub-article 3 is a provision whereby 370 can be extinguished. That's the distinction.
But I'm on a little wider argument made by the other side. Para 19, the submission, my Lord Justice. The submission advanced by Mr. Sorabji, the learned senior counsel, appearing on behalf of the writ petitioner in writ petition number so and so are thus: Article 291, 362, and 366(2). Well, 366(2) is the definition clause defining princes then of the Constitution, were integral part of the constitutional scheme and form the important basic structure, since the underlying purpose of these articles was to facilitate submission of new order and ensure organic unity of India. These articles guaranteed pledges to the rulers based on elementary principles of justice, and in order to preserve the sanctity of solemn agreements, it was only by the incorporation of these articles that the unity of India was achieved by getting all the rulers within the fold of the Constitution, and that the deletion of these articles has damaged and demolished the very basic structure of the Constitution. The covenants entered into were in the nature of contracts which had been guaranteed constitutionally and affirmed by making the privy purse an expenditure charged under the Consolidated Fund of India, and the use of expression guaranteed or assured by the Government of Dominion of India to any ruler as embodied in Article 291, and the expression guarantee and assurance given under such covenants or agreements as is referred to in Clause 1 of Article 291 as comprised in Article 362 was a permanent feature of the Constitution, reflecting the intention of the founding fathers of the Constitution, and as such, these two articles should have been kept intact. Please pause here for a minute. My Lord, these articles even remotely did not suggest that they are temporary. As against, my Lord, 370, which by its very definition says and it's temporary, and I will also, my Lord, be able to attempt to demonstrate that it could never have been but for temporary. Such a drastic provision, the visionary fathers and mothers of the Constitution would never have kept it permanent, where two organs can change the Constitution the way they like. But that's a separate argument. Please see. According to the learned counsel, the deletion of these articles amounted to a gross breach of principles of political justice enshrined in the preamble by depriving or taking away from the princes the privy purses which, which were given to them as consideration for surrendering all their sovereign rights and contributing to the unity and integrity of the country, and that the deletion of these articles by the Impugned Amendment Act is arbitrary, unreasonable, and violative of Article 14 of the Constitution. Further, it has been urged that rulers acceded to the dominion of India and executed instrument of accession and covenants in consideration of the pledges and promises enshrined in Article 291 and 362, and that the Impugned Amendment Act is beyond and outside the scope and ambit of the constitutional power of Parliament to amend the Constitution as provided under 368. Mr. Sorabji, in his additional written submissions, has further urged that without the cooperation of rulers, not only the territory of India, its population, the composition of the state legislatures, the Lok Sabha, the Rajya Sabha, but also Constitution that was adopted on November 26, 49, would have been basically different, and that India, that is Bharat, would have been fundamentally different from the Bharat that came into being. But kindly see, my Lord, para 22. Mr. Salve, the learned senior counsel, contended that he was also for the petitioner, my Lord, with Mr. Lord Sorabji.
But estoppel doesn't apply to him.
Pardon me?
Estoppel doesn't apply to him based on what he argued in that case.
Well, that's the my Lord, privilege on this side, my Lord. We are not bound by our arguments, my Lord. Mr. Salve, learned senior counsel, contended that Article 291 and 362, when
Yes.
Mr. Salve, the learned counsel appearing, contended that Article 291 and 362 when incorporated, were intended to grant recognition to the solemn promises on the strength of which the former rulers agreed to merge with the Indian Dominion, and the guarantee of privy purses and certain privileges was as a just quid pro quo for surrendering their sovereignty and dissolving their states. It has been stated that constitutional guarantees and assurances promising continuance of privy purse as enshrined in the agreements and covenants were an integral part of the constitutional scheme and an important part of the constitutional structure, and they were to be fully honored and not cast away on a false morass of public opinion or buried under the acts of states. But the impugn ex specie has abolished and destroyed those constitutional provisions of Article 291 and 362 affirming the guarantees and assurances given to the rulers under those agreements. Then your lordships may kindly come to para 23. It is further emphasized that Sardar Patel, who made it clear that according to the vision and views of the constitution makers, the guarantees of privy purses, privileges, etc. were perfectly in keeping with view the democratic ethos and principles of Indian people. Then the learned counsel stated that views expressed in the Constituent Assembly were unanimously accepted and there was no dissent, and that in fact the closing remarks in the debate of Dr. Patabi Sitaramaiah were only remarkably confirmatory of the permanence and indefeasibility of the aforesaid guarantee and assurances, but also went a long way in determining that the said guarantees and assurances have come to stay as an integral and untouchable part of the basic structure of the Constitution. Finally, it was said that there can be no basic structure of a Constitution divorced from the historical evolution of precepts and principles on which the Constitution is founded. Any effort to determine the basic structure of the Constitution without keeping a finger on historical pulse of the Constitution may well lead to substantial injustice. According to him, if the historical approach to the test of basic structure is kept in view, the guarantees and assurances of the privy purses, privileges, etc., granted by the Constitution makers by incorporating Article 291, 362, and 36622 in the Constitution framed by them would, without any doubt or dispute, emerge in their own right as basic features of the Constitution which cannot be abrogated or annihilated by any constitutional amendment, etc. Now, your lordships, my lord, kindly see para 28 at page 551. Learned Attorney General of India, with regard to the above pre-constitutional agreement, stated that history of the developments leading to the merger agreements and framing of the Constitution clearly show that it is really the union of people of native states with the people of erstwhile British India, and the instruments of accession were only the basic documents but not the individual agreements with the rulers, and therefore to attribute the agreements entered into by rulers as a sacrifice by the rulers is unfounded. Secondly, the nature of the covenants is not that of a contract, because a contract is enforceable at law, while these covenants were made non-justiciable by a constitution, vide Article 363. According to him, the covenants were political in nature, and that no legal ingredients as the basis can be read into these agreements, and that the guarantees and assurances embodied in Article 291 and 362 were guarantees for the payment of privy purses. He has urged that such a guarantee can always be revoked in public interest pursuant to fulfilling a policy objective or the directive principles of the Constitution. That being so, theory of sanctity of contract or unamendability of Article 291 or 362 did not have any foundation. He continues to state that the theory of political justice is also not tenable, because political justice means the principle of political equality, such as adult suffrage, democratic form of government, etc. In this context, your lordships can skip, my lord, the citation. Then para 29. Before embarking upon a detailed discussion on the various facets of the contentions, both factual and legal, we shall deal with the precursive point with regard to the pre-constitutional instruments of accession, the merger agreements, and the covenants which guaranteed the payment of privy purses and recognition and personal privileges, etc., and which the agreements ultimately facilitated the integration of these states with dominion of India. Then, my lord, 30, your lordships may skip its history. 31. This accession of Indian states to the dominion of India established a new organic relationship between the states and the government, the significance of which was forging of a constitutional link or relationship between the states and dominion of India. The accession of Indian states to dominion of India was the first phase of the process of fitting them into constitutional structure of India. The second phase involved a process of twofold integration, the consolidation of states into sizable administrative units and their democratization. Though high walls of political isolation had been raised and buttressed to prevent the infiltration of the urge for freedom and democracy into Indian states, with the advent of independence, the popular urge in the states for attaining the same measure of freedom as was enjoyed by the people in the provinces gained momentum and unleashed strong movements for the transfer of power from rulers to the people. On account of various factors working against the machinery for self-sufficient and progressive democratic setup in the smaller states and serious threat of law and order in those states, there was an integration of states, though not in a uniform pattern in all cases. Firstly, it followed the merger of states in the provinces geographically contiguous to them. Secondly, there was a conversion of states into centrally administered areas. And thirdly, the integration of their territories to create a new viable units known as Union of States. My lord, your lordships may, my lord, now come to para 38, my lord, at page, my lord, 554, PDF 554. Now, my lord, the Honorable Court discusses Madhav Rao, because Madhav Rao obviously was cited, which said that privy purses are an integral part of the Constitution of India. That is one. And number two, that you could not have taken it away by merely deleting the definition of princes. These were, my lord, the two. Then 38. On May 14, 1970, the Constitution 24th Amendment Bill for abolition of the aforesaid privy purse, privileges, etc., conferred under Article 291, 362, and 36622 was 366-22 was introduced in Lok Sabha by the then Finance Minister Sri Chavan. The bill contained 3 clauses and a short statement of objects and reasons. The statement reads as under: the concept of rulership with privy purses and special privileges unrelated to any current function and social purposes is incompatible with an egalitarian social order. Government have therefore decided to terminate the privy purses and privileges of rulers of former Indian states. On September 2, the bill was voted upon in Lok Sabha, but on September 5, Rajya Sabha rejected the same, since the bill failed in the Rajya Sabha to reach the requisite majority and not less than 2/3 present as required by Article 368 and voting. Close on the heels of the said rejection, the President of India, purporting to exercise his powers under Clause 22 of Article 366 of the Constitution, signed an order withdrawing recognition of all rulers of the country en masse. Look, this was the subject matter in Madhav. A communication to this effect was sent to all rulers in India who had been previously recognized as rulers. So what was done was, by a constitutional order, which is unheard of, except in 370, the Honorable President virtually declared 2 provisions to be nullity. The presidential order, para 40, de-recognizing the rulers were questioned in Madhav Rao, Scindia versus Union of India, by filing writ petition under Article 32, challenging it as unconstitutional, ultra vires and void. An 11-judge bench of this court, by its judgment dated so-and-so, struck down the presidential order being illegal, ultra vires and inoperative on the ground that it had been made in violation of power of the President of India under Article 366(2) of the Constitution, and declared that writ petitions would be entitled to all their pre-existing rights and privileges, including right to privy purses, as if the impugn orders therein had not been passed. Here, it may be noted that Justice Mittar and Justice Ray gave their dissenting judgment. Thereupon, that they started getting privy purses. Kindly come to para 77 at page 562. Rest, my lord, may not help, my lord, assist your lordships, my lord, either way. 77. According to Mr. Swaraj, para 77.
Just one.
Your lordships would, I'm sorry, my apologies.
In the merger or the other agreements, that the President of India will recognize the ruler or something because of inheritance and otherwise. That was there.
Yeah,
That
but
was
366.
there was some stipulation because those the rule of primary nature and other things were all recognized in that. That's how.
Yes, but every ruler was
You're
apart
nodding
from.
the head because you argued that.
This guaranteed them not only privy purses, some privileges.
Correct.
All states were divided into gun salute states. Somewhere 21 gun salute, somewhere the smallest was one gun salute.
They did refer to presidential orders in that merger agreements also. No. At that time, there won't be any president as such.
No, my lord, there was none.
No. Because at the time when the agreements were signed, there won't be a.
Thereafter, the constitution was made and the honorable president was elected.
The petitioner.
The merger agreements were signed by Dominion of India or subsequently Government of India by the Secretary, Minister of State, Ministry of State. VP Menon, Lord, essentially is the signatory.
And 75 make a brief reference.
Yes,
Para 74 and 75, there is a brief reference to all these agreements.
correct. I'm open. Your lordships are on para. Lord, may I read para 75? Lord? May I?
Yes, para 75.
70. Therefore, there cannot be, my lord, it is on page 561. Possibly that's what, my lord, the Honorable Court is reading. Therefore, there cannot be any justification in saying that guarantees and assurances given to the rulers were sacrosanct, and that Article 291 and 362 reflected only the terms of the agreement and covenants. In fact, as soon as the Constitution came into force, the memoranda of agreements executed and ratified by the State of Union of States were embodied in formal agreements under the relevant articles of the Constitution, and no obligation flowed from those agreements and covenants, but only from the constitutional provisions. To say differently, after introduction of Article 291 and 362 in the Constitution, the agreement and covenants have no existence at all. Everything gets subsumed in the Constitution itself.
In fact, that is the proclamation which Karan Singh issued after the adoption of the Indian Constitution.
49.
That thereafter, the entire relationship will be governed by the Indian Constitution.
Yes.
And all previous covenants, agreements will cease to have any application.
They are, therefore, I said, it gets subsumed. And now the final document is the Constitution of India, which we have given to ourselves. To say differently, after the introduction of Article 291 and 362 in the Constitution, the agreements and covenants have no existence at all. The reference to covenants and agreements was casual and subsidiary, and the source of obligation flowed only from the Constitution. Therefore, the contention urged on the use of the words guaranteed or assured is without any force and absolutely untenable. The next vital issue is whether the Impugned Amendment Act damaged any basic structure or essential feature of the Constitution. According to Mr. Sorabji, the repeal of Article 291 and 362, which were an integral part of the constitutional scheme, the identity of the Constitution has been changed and its character has been fundamentally altered. The total repeal of these articles, coupled with an express repudiation of the guarantees embodied therein, has resulted in nullification of a just quid pro quo, which were the essence of these guarantees. He has urged that the underlying purpose of doing justice to the rulers has been subverted and breach of faith has been sanctioned. He has relied upon these judgments, including, my Lord, 3 is Madhav Rao Scindia. And please see, my Lord, 79. Mr. D.D. Thakur, Lord, father of my Lord Justice Thakur. My Lord, the Chief Justice Thakur. D.D. Thakur, in addition to the above, has stated that one of the tests to determine whether the provision of the Constitution was intended to be permanent or could be deleted or amended is to see whether the Constitution makers had intended that to be made permanent. In support of this submission, he placed much reliance on the observations of Justice Mudholkar in Sajjan Singh. My Lord, I can skip that. And thereafter, my Lord, I may directly come to 88 at page 563. Your Lordship has it. My Lord Justice Gavai and Justice Sorabji. Mr. Soli Sorabji, in support of his contention that Article 291 and Article 362 and Clause 22 of the Article 366 were integral part of the constitutional scheme, which otherwise would mean the essential part of the constitutional scheme referred to Webster's Dictionary and Collins' Concise Dictionary, and has pointed out the lexical meaning which says the integral means essential, and therefore, according to him, the total abolition of provisions of the Constitution, which are in its integral parts, otherwise essential parts, has damaged the essential and basic features of the Constitution. To draw strength for his submission, he relied upon certain observations made by Justice Shah in his judgment in Madhav Rao, observing, now, my Lord, Madhav Rao is dealt with, my Lord, and distinguished by the provisions enacted in Article 366(22), 291 and 362 of the Constitution. The privileges of rulers are made an integral part of the constitutional scheme, and an order merely derecognizing a ruler without providing for continuation of the institution of rulership, which is an integral part of the constitutional scheme, is therefore plainly illegal. The learned Attorney General has vehemently opposed the above submission, stating that the expression integral part of the scheme of the Constitution used in Madhav Rao are not the same as the basic structure, and that expression has to be read in the context of a challenge to the ordinance which sought to render nugatory certain rights guaranteed in the Constitution then existing. It is further stated that the attack on 26th Amendment based on principles laid down in Madhav Rao is totally misconceived, because only in order to overcome the effect of that judgment, the 26th Amendment was passed by Parliament in exercise of its constituent powers. The President exercised executive power, which he did not possess. Just to contrast, Article 370 has a constituent power in the President under sub-Article 3, the self-extinguishing provision. According to the Attorney General, the observations in the said case were nullified by the amendment, and the judgment is no longer good law after the amendment. To test the amendment on the basis of that judgment is impermissible, and all the arguments based upon this case are therefore misconceived. Then 91. After the commencement of the Constitution, in pursuance to Article 36622, the rulers were recognized and they had been enjoying the privy purses, privileges, dignities, etc. on the basis of relevant constitutional provisions. Pursuant to the resolution passed by All India Congress Committee in 1967, the Union of India introduced the 24th Amendment Bill in 1970 to implement the decision of the All India Congress Committee favoring the removal of privy purses, privileges, etc. But the bill, though passed in Lok Sabha, failed to secure the requisite majority in Rajya Sabha, and therefore it lapsed. It was only thereafter that the President of India issued an order in exercise of powers vested in him under Article 366(2), changing the definition clause by an ordinance. Sorry, my Lord Justice.
Please continue.
I'm sorry. 36622 de-recognizing the rulers and stopping the privy purses, privileges, etc. enjoyed by the rulers. Now, this is important, my Lord. This is the distinction. This order passed by the President was the subject matter of challenge in Madhav Rao 2. The Supreme Court struck down the order of the President as invalid, as in the view of the court, de-recognition of rulers would not take away right to privy purses when Article 291 and 362 were in the Constitution. This is the ratio, that you can't delete a definition while retaining the constitutional rights guaranteed under 291 and 362. It was only in that context the observations which have been relied upon by Mr. Sorabji were made. The 26th Amendment itself was passed by Parliament to overcome the effect of this judgment. Now, by this amendment, Article 291 and 362 are omitted. Article 363A is inserted and Clause 22 of Article 366 is amended. Therefore, one cannot be allowed to say that the above said omitted articles and amended clause were the essential part of the constitutional scheme. So, they have to be read only in the context of a challenge made to the presidential order, which sought to render nugatory certain rights guaranteed in the Constitution, which were then existing. In any event, the constitutional bar of Article 363 denuates the jurisdiction of any court in disputes arising from covenants and treaties executed by the rulers. The statement of objection reasons of 26th Amendment clearly points out that the retention of the above articles and continuation of the privileges and privy purses would be incompatible with the egalitarian society assured in the Constitution, and therefore, in order to remove the concept of rulership and terminate the recognition granted to ruler and abolish the privy purses, this amendment was brought. Now, 92 is very important, Lord, which would also assist your Lordship on the question of federal diversity. We are of the opinion that the observations of Justice Shah in Madhav Rao that privileges of rulers are made an integral part of the constitutional scheme, and that the institution of rulership is an integral part of the constitutional scheme must be read in their proper context. That was a case whereby a presidential order, The rulers were deprived of their privy purses and other privileges while keeping Article 291 and 362 intact in the Constitution. This doesn't arise here, my lords. Indeed, the said presidential order was issued after the government failed in its attempt to effect an amendment on those lines. It is in that connection that learned judge made the above observations. It is clear that the learned judge used the word integral part in their ordinary connotation, not in lexicographical sense. Ordinarily speaking, integral means of a whole or necessary to completeness of a whole, and as forming a whole. Our constitution is not a disjoint document. It incorporates a particular socio-economic and political philosophy. It is an integral whole. Every provision of it is an integral part of it. Even the provisions contained in Article 21, temporary, transitional, and Part 21, temporary, transitional, and special provisions. One may ask, which provision, which concept, or which institution in the Constitution is not an integral part of the Constitution? He will not find an answer. To say that a particular provision or a particular institution or concept is an integral part of the Constitution is not to say that it is an essential feature of the Constitution. Both are totally distinct and qualitatively different concepts. The said argument is really born of an attempt to read a judgment as a statute. One may tend to miss the true meaning of the decision by doing so. We may say the aforesaid observations of Justice Shah constituted the shit anchor of the petitioner's argument relating to the basic structure. My lord, just similarly, federalism is also, my lord, a basic structure. But the federal diversity can still exist within federalism. But my lord, that's a separate issue. In the above premise, it is not permissible to test 26th Amendment with reference to observations made in Madhav Rao. But now kindly come to para 96 at page 566. Yeah. Permanent, your lordship, yes. Para 96 at page 566.
Yes.
Permanent retention of the privy purse and the privileges of rights would be incompatible with the sovereign and republic form of government. Such a retention will also be incompatible with the egalitarian form of our constitution. That is the opinion of the parliament, which acted to repeal the aforesaid provisions in exercise of its constituent power. The repudiation of the right of privy purse privileges, dignities, etc., by deletion of Article so and so, which the recognition of the rulers and payment of privy purse are withdrawn, cannot be said to have offended Article 14 or 19 1F. And we do not find any logic in such submission. No principle of justice, either economic, political, or social, is violated by the 26th Amendment. Political justice relates to the principles of right of the people, that is, right to universal suffrage, right to democratic form of government, and right to participation in political affairs. Economic justice is enshrined in Article 39 of the Constitution. Social justice is enshrined in, well, lordships can skip that. 97. A serious argument has been advanced that the privy purse was a just quid pro quo to the rulers of Indian states for surrendering their sovereignty and rights over their territories, and that move for integration began on a positive, promising note, but it soon degenerated into a game of maneuver, presumably as a deceptive plan of action. This argument, based on the ground of breaking of solemn pledges and breach of promise, cannot stand much scrutiny. To say that without voluntary accession, India, that is Bharat, would be fundamentally different from that Bharat that came into being prior to the accession is untenable, much less inconceivable. Please mark this, Malad. Beautiful words. One should not lose sight of the fact that neither because of their antipathy towards the rulers nor due to any xenophobia did the Indian government entertain the idea of integration, but because of the will of the people. It was the people of the state who were basically instrumental in integration of India. It would be apposite to refer to the observations of Justice Bose in Virender Singh's judgment. Every vestige of sovereignty was abandoned by the dominion of India and the states and surrendered to the people of the land who, through their representatives in the Constituent Assembly, hammered out for themselves a new constitution in which all were citizens in a new order, having but one tie and owing but one allegiance, devotion, loyalty, fidelity to the sovereign democratic republic that is India. Thereafter, it is also worthwhile to take note of the historical process of states integration. Your Lordships may directly can come to 109 at page 569, 107. On a deep Your Lordship, yes, my Lord. Para 107. On a deep consideration of the entire scheme and content of the Constitution, we do not see any force in the above submission. In the present case, there is no question of change of identity on account of 26th Amendment. The removal of Article 291 and 362 has not made any change in the personality of the Constitution, either in its scheme or in its basic features or in its basic form or its character. But please read 370 in this. Does it change the personality of the character of the Constitution? The question of identity will arise only when there is a change in the form, character, and content of the Constitution. In fact, in the present case, the identity of the Constitution, even on the test proposed by the Council for writ petitioners and interveners, remains the same and unchanged. Sri So-and-so has contended that by removing the real and substantial distinction between erstwhile princes forming a class and the rest of citizenry of India, the constitutional amendment has at one stroke violated the basic structure of the Constitution as reflected both in Article 14 and 51C and treated unequals as equals, thereby giving a go-by to a solemn treaty obligation which was sanctified as independent constitutional guarantee. 109, this is very, very important and crucial for our purpose, the purpose of the respondents. After carefully going through the above decisions which relate to service matters, we are afraid that such an argument as one made by Sri So-and-so could not be substantiated on the principles laid down in these two decisions that Article 14 will be violated if unequals are treated as equals. In our considered opinion, this argument is misconceived and has no relevance to the facts of the present case. Please note this. One of the objectives of the preamble of our Constitution is fraternity, assuring the dignity of the individual and the unity and integrity of the nation. It will be relevant to cite the explanation given by Dr. Ambedkar for words fraternity, explaining that fraternity means a sense of common brotherhood of all citizens. No region, no part of the region, no citizen staying in any region should get any different treatment than rest of the country. In a country like ours, with so many disruptive forces of regionalism, communalism, and linguism, it is necessary to emphasize and re-emphasize that unity and integrity of India can be preserved only by a spirit of brotherhood. India has one common citizenship, and every citizen should feel that he is Indian first irrespective of other bases. Therefore, I started by saying that a psychological duality in the mind is now completely gone. In this view, any measure, please mark this, in this view, any measure at bringing about equality should be welcome. There is no legitimacy in the argument in favor of continuance of princely privileges, since we have held that abolition of privy purses is not violative of Article 14. It is unnecessary for us to deal with the cases cited, which according to him go to say so and so. Then 1110. One of the arguments advanced by Mr. D.D. Thakur is that the Constitution should be read in the context of a pluralistic society of India, where there are several distinct and differing interests brought together and harmonized by the Constitution makers by assuring each section, class, and society preservation of certain political, cultural, and social features specific to that class or section. By way of example, reference to Article 370, which confers a special status for Jammu and Kashmir, is made. He continues to state that likewise in the northeastern states, the tribals were given autonomous powers for their district councils co-equal to what is conferred on the states, and that the minorities special provisions are made in Article 30. Besides, Article 25 and 26 are meant to safeguard the minorities and religious denominations. The persons to determine the injury will be those for whom these provisions were made and whose interests are prejudiced. According to him, in such a circumstance, the assurance and guarantees given under Article 291 and 362, which are the Magna Carta, assuring the rulers of their pre-existing rights, cannot in any way be destroyed. We do not think that the aforesaid special provisions have any relevance here. As repeatedly pointed out supra, the only question whether there is any change in the basic structure of the Constitution by deleting Article 291 and 362 and by insertion of Article 363A and amendment of Clause 22 of 366. We have already answered this question in the negative, observing that the basic structure of the essential feature of the Constitution is or are in no way changed or altered by the impugned amendment. We cannot make surmises of its ifs and buts and arrive at conclusion that Article 291 and 362 should have been kept intact as special provisions made for minorities in the Constitution. It is but a step in the historical evolution to achieve fraternity and unity of the nation, transcending all regional, linguistic, religious, and other diversities, which are the bedrock on which the constitutional fabric has been raised. The distinction between the erstwhile rulers and the citizenry of India has to be put an end to so as to have a common brotherhood. The court traces it to fraternity mentioned in the preamble. Lord, even removal of some provision according to this judgment can further the constitutional objective and can be in furtherance of the basic structure of the Constitution. Fraternity, equality is a basic structure of the Constitution. It's a part of brotherhood, it's a part of equality, part of fraternity. And if any provision which keeps out of the total composition of our Constitution as an appendage, as a transitory provision, to be removed at an appropriate stage, if it is removed, it furthers the basic structure and it enhances the equality and fraternity, which is the bedrock of the Constitution.
Yes.
In this view, it, in my respectful submission, may not be necessary to read Madhav Rao Scindia judgment. If your lordship would wish me, I can assist your lordship with that. But we will, ultimately read the same paragraphs based upon which, it is distinct. That when you are doing something, earlier, it was done by a presidential order in Madhav Rao. One definition was deleted, which the president did never possess. Even today it doesn't possess. But only in one provision, that is 370, where you can amend any part of the constitution. So explanation 367 mechanism is used. But this is the drastic nature of this provision. 371 permits two organs, the government of the president, president would mean act and advise, aid and advise, and the government of the state, again aid and advise. But please, my lord, appreciate this. Two individuals technically, the prime minister and the chief minister of the state, whoever he is, can make any change, can make any alteration, can choose not to apply any provision, and like 35A, can create a constitutional provision only applicable to Jammu and Kashmir. That provision is exercised now as a last exercise to ensure that it never happens. 367 explanation is added. I'll come to that.
Of this?
But my learned friend wants me to. Yes, there is a concurring judgment, Malad.
Justice Mohan.
Justice Mohan, PDF 577, Malad. Just note the paragraphs, Malad. There are 151, 152, and 118, Malad.
180.
118, Malad. Yes, Malad. Yes, I'm sorry, Malad. 206. It's at page, I'll just read, your lordship need not go to, it's a 2-line paragraph, my lord, but a very 594, PDF 594. This is, my lord, the concurring view, Justice Mohan, my lord, Justice Mohan. Therefore, this court cannot concern itself with the moral aspect of the impugn amendment. The impugn amendment is the will of the people expressed through parliament. Lord, here the parliament has examined on 4 occasions with 2/3 majority in both the houses. Lord, in Madhav Rao Sindhia judgment, Lord, if your lordships can note the paragraphs which we would be reading. Lord, since it's already 11:45, my lord, I don't wish your lordship's time, my lord. I, if possible, my lord, conclude at 1 o'clock. Lord, in Madhav Rao Sindhia, my lord, we will be relying upon 97, 109, 119, 120, 125, 126, 143, and 145. And 145. Ultimately, it turned that without deleting Article 291 and 362, whether presidential order can be used, by deleting the definition only. That was the discussion, which is distinguished, my lord, in this judgment. Now, my lord, with your lordship's permission, my lord, I may go
But,
to.
Mr. Solicitor, can the abrogation stand independent of the modification which is made to Article 367 here?
Lord, that is my submission. Lord, even in absence of the proviso, Lord, explanation, the last explanation, what it does, it merely substitutes the term constituent assembly
With legislative assembly.
Lord, my submission is going to be that when the constituent assembly is dissolved without any recommendation, that part of the requirement goes, because proviso becoming otiose cannot result into the main provision becoming inoperative. Then the president was left to his own choice.
And
367 mechanism is affirmed, my lord, in Damnu, your lordships have seen. My lord, so far as 370
What
is
was done in Madara was that a presidential order was issued, because if you see the provisions of Article 366,
yes,
22, as it stood prior to the amendment by the 26th Amendment. If you have this red book, it may not be in that, you'll have to get it in the red book at page 372.
I guess.
That said, ruler in relation to an Indian state means the prince, chief, or other person by whom any such covenant or agreement as is referred to in clause 1 of Article 291 was entered into, and who, for the time being, is recognized by the president as the ruler of the state, and includes any person who, for the time being, is recognized by the president as a successor of such ruler.
Yes.
Now, what happened there was, initially, after the proposed amendment didn't pass muster in the Rajya Sabha, a presidential order is issued, purportedly under clause 22. And the object was, now we are de-recognizing you. If you are being de-recognized, you lose the benefit of your privy purse in Article 291. That was the
Presumed to
argument.
be the consequence of de-recognition.
Right. So this was done in exercise of the power which was conferred under clause 22 as it then stood prior to the 26th Amendment. Our court said, look, by recourse to a presidential order, you cannot override a substantive provision of the Constitution, namely Article 291 and Article 362. That was Madhura's India.
Correct.
Then came the Constitutional Amendment, which was upheld against the challenge on the ground of the basic structure violation. Argument in this case is that what you have done essentially here is worse, because there was a presidential order in exercise of a provision in Article 366, which gave the president the power to recognize or de-recognize a ruler. Here what is being done is that 367 itself is sought to be amended in exercise of the, during the, we've seen
Operating
the
370.
To amend 370.
Which has been done consistently and affirmed by your lordships. The distinction is twofold distinction. A, 370 is the only article, was the only article which permitted the president to change any other article. So 367, your lordships have shown, I have shown the chart, that 367 mechanism was used in past. That has been the convention. So the only thing which happened, my lord, on 5th and 6th of August was that using the mechanism of 367, the Constituent Assembly was changed. It is not worst. There, my lord, there is a
367 mechanism which was used earlier to, for instance, substitute, the Sadar Riyasat, etc. That was with the concurrence of the assembly.
No. Only once. That was 370 sub-article 3. This, my lord, use of 367 is, kindly, my lord, see the distinction. What was done with the concurrence was under 370 sub-article 3. Constituent Assembly was there in 1952. It recommended and the change was made. This time, it is under 371D. So this time, I may emphasize, my lord, so that I'm sorry, I was not clear. I'm sorry, my lord Justice called once. May I request your lordships to take 370 once again, my lord, for the time being, to make myself clear, my lord. That, my lord, would answer my lord's query, my lord, to my lord's satisfaction. Your lordships may come to, I'll show only two provisions, my lord. 371D. Your lordships have 371D, my lords.
Yes.
This is the first power. Such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. Correct, my lords? Now read 3. Kindly read 3. Notwithstanding anything in the foregoing provisions of this article, the President may, by public notification, declare that this article shall cease to be operative. That is first part. Or shall be operative only with such exceptions and modifications, and from such date as he may specify. This is the power of extinguishing or partly extinguishing. So now this is crucial, my lord, apropos my lord's question.
Yes.
The first exercise, as your lordships have rightly said, was under 3. Because the Constituent Assembly was in existence, it recommended. Rest, whenever there were modifications made in 367, were made under 1D. All rest, all under 1D, including this one.
With the concurrence of the government.
Concurrence of the government.
The reason for that was very simple, because you are amending the constitution and you are not dealing with subclause 3 or
3, yes.
you're not dealing with subclause 3.
I'm not dealing. I dealt with at the end on my lord, 6th of August.
Because subclause 3 only deals with 370 itself.
Itself, not other, your lordships are right, not other part of the Constitution.
Because D refers to other provisions, because before D you have C.
Yes.
C says that the provisions of Article 1 and of Article 370 shall apply to the
Yes.
state of Jammu and Kashmir.
Correct.
Therefore, in that sense, it freezes the provisions of Article 370 in relation to the state of Jammu and Kashmir. Now, what it does is, therefore, it says other provisions of the Constitution shall apply subject to such exceptions and modifications. Therefore, other provisions will mean provisions other than Article 1 and Article 370
And 370 itself.
and 370 itself.
Correct.
Therefore, if you have to make an alteration of 370 or abrogate its status or reduce it or dilute it or alter it, you have to follow
3
equals to 3,
Correct, my lord.
right?
But, my lord, kindly, I'm sorry, my lord, I'm almost reaching, my lord, at your lordship's level.
But then
No.
can you do that? Can you do
Exactly,
that
that's what I'm
using
answering.
the power under 367 then? That's the point.
Exactly, that's what I'm answering. I cannot do that under sub-article 3. 367, I cannot modify under sub-article D. That I can do, and I have done only under 371D. It has been used as a mechanism, and Damnu approves it.
Right, we have seen Damnu.
Any-
We are now just looking at it, we are looking at it as a matter of first impression.
Correct, madam. The first impression.
Can you alter the import of a provision of Article 370 itself by a process other than 3? Because what you
No.
have done essentially here is
No, no.
that you have used 367 to amend the proviso to 370.
Correct. No, not amend. 367 is explanation. That instead of A, it would be B. It may have an effect of amendment.
Whether you call it an explanation or an amendment,
Yes.
one thing is very clear, that the amendment to 367 has the consequence of now reading the words Legislative Assembly in place of Constituent Assembly.
Which in fact was not necessary. But yes, it was done. But not under 370. It was done under first. The first step was, my lord, the first step was the President under 371D added the explanation that henceforth.
But the question being put to you is slightly, I think, different.
Ah.
The question is, by making the amendment in 366, by equating Constituent Assembly with the Legislative Assembly, aren't you in fact amending Article 370? Why, without taking recourse
to 373.
to clause 3 of 370, because Article 370 can be only amended in terms of clause.
Clause 3.
No, I understand. But then, my lord, it has the effect of it becoming permanent. Because there is no constituent assembly. So it can never be modified. 370 can never be modified.
Can take recourse. I mean, the argument on the other side is this, that you can take recourse to clause D of subclause D of clause 1 in a situation where you have to amend any other provision of the Constitution other than Article 370.
No, how?
But can you take, yes,
It doesn't say so.
It's very clear. It says
Such
on
other
the
provisions.
other provisions of
Other means except 1 and 370.
So you are saying such other provisions will include 367. Mr. Solicitor.
Yes.
All right, Mr. Civil, let's answer again. That doesn't matter. Let's not.
Quite often, I think I should be accustomed to Malad.
We are posing
Yes.
an issue because we have to deal with these issues. So we want to elicit a response.
Yes.
371D refers to other provisions of the Constitution. Other provisions of the Constitution, according to you, would include 367. Possible. We are not ruling this out at all. We will test that hypothesis. But can you use 367 and amend 367 to bring about an amendment to 370? If you do that while exercising the power under 371D, then are you not really doing that to amend 370 itself? Because the only provision which the Constitution creates to amend 370 is 370 clause 3. What you are now doing is, according to them, is that you are using the amendment of 367, applying the provisions of 371D to bring about an amendment to 370 itself. Whereas the purpose of 371D is to amend some other provision of the Constitution. True, 367 is another provision of the Constitution, but can you use that to amend then 370 itself? That's the point which you have to answer.
Lord, I can assure my learned senior.
No, please.
No, I can assure him, nobody can disturb me or derail me without my consent. I am quite accustomed to such interruptions.
Mr. Solicitor, please don't get derailed because this is the heart of the matter.
No, I know that. And he also knows. But I'm quite accustomed.
Some clarity on this is necessary.
Yes.
Let's sit down and do it for
What
5
will
minutes
be,
and then we have to
I will
deal with
put
this
it
part.
slightly differently. I'll put it differently. The interpretation which your lordships are, my lord, prima facie now testing.
We're testing it.
No, we are testing it. The prima facie testing it. Lord, what will be the impact of that interpretation? I'll read, my lord, the entire Article 370. Meaning thereby, my lord, in absence of a constituent assembly, which can never be modified, the sub-article 3 can never come into effect, come into operation, and 370 gets the status of a permanent provision. No, please read it in totality. My lord, please read the entire article. My lord, for my satisfaction, please have a look at, my lord, the entire article. Notwithstanding anything in this constitution, your lordships can skip. The power of parliament to make laws for the said state shall be limited to those matters in the union list and concurrent list. Your lordships have seen, my lord, those the precedent here.
Session.
The provisions of Article 1 and of this article shall apply in relation to that state. The purpose is that Jammu and Kashmir can do nothing in their constitution, or even Parliament can do nothing in their constitution. Kindly appreciate, my lord. The difficulty, my lord, if your lordships accept that, then even 368 route, which is the second route suggested, cannot be done. Because it says 1 and this article shall remain. If that is the meaning given, that is completely unalterable, then 370 remains as a permanent, though there are a host of considerations for me to show that it has always been a temporary feature. Further, such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the president may by order specify. My lord, other provisions would mean other than B.
Yeah, just stopping you for a minute. Could the Legislative Assembly make a recommendation in terms of 371A saying that under 367 you equate Constituent Assembly with Legislative Assembly?
Under 371,
1D. 370 sub clause 1 subclause D. Could the Legislative Assembly make a recommendation saying,
if it is amendment, it cannot. If it
just think about it and then answer. Could the Legislative Assembly make a recommendation to the Parliament, please amend Article 367 and
No, let me give it a thought and my lord respond to that. My lord, that I understand the heart of the matter. Your lordship's lord discussion, my lord, is driving that any 367 use which has the impact of altering 370 itself, my lord, then my lord, we would be setting at not all 367 usages. But kindly remember, through the 367 mechanism, 370 has been modified.
That's the point in favor of what you are saying, with the caveat that the use of the 367 mechanism to modify 370 was always with the consent. Sorry, consent.
Here also it is concurrence. The only difference.
It was concurrent.
Yes,
That's
this is
the very one. That is constitutionally the significant difference.
But this is
Now, what
also
if
with
we can't
concurrence.
see?
Look, this is also with concurrence. The only difference is the concurrence of the governor, because governor steps into the shoes of the government.
So there is a difference between concurrence and recommendation.
Correct. But
Concurrence
for
can be subsequent, recommendation has to be.
the recommendation is of the body, Constituent Assembly as it stood, and subsequently, if we are right, Legislative Assembly. Concurrence of the government. Please see, my lord. And government, the only dispute was that government cannot mean governor. Please see, my lord, concurrence provision, second provision.
Concurrence of the government means that Council of Ministers.
Council of Ministers, if it is there, otherwise powers are exercised by the governor. And that's why, my lord, I pointed out that there are several exercise of 371D when there was a precedence rule with concurrence of the governor.
At least you have provided yesterday.
At least not-
At least you have read it as well.
Yes. My lord, your lordship's query is, my lord, absolutely, my lord, dot on the point. But, my lord, I'll respond, my lord. Let me give it a thought. But the real question would be,
You have already responded.
well, the real question is, my lord, that here concurrence is that of the governor. Government, whichever is the government, if it is ministry, then cabinet, aid and advice, otherwise the governor. And during governor's rule, 371D is used to change 367 also. Not change is a incorrect word I am. To put an explanation, to give meaning to 370.
So simply put, according to you, at a time when there was no legislative assembly, the explanation was amended so as to incorporate
Democratize.
so as to provide that the Constituent Assembly shall itself be treated as the Legislative Assembly.
Because it was so treated
Because the
early.
Constitution had not been framed and there was no Legislative Assembly in the state of Jammu and Kashmir. So according to you, the flip side now is that when there is no Constituent Assembly, we treat the Legislative Assembly as a Constituent Assembly.
To democratize, my lord. Otherwise, my lord, kindly see. Suppose the government took the decision. Government took the decision. My lord, suppose.
The second answer could be, and that's for the other side to answer, by amending 367, in fact, you're not really amending 370 as such, because the 370 procedure has to be still applied to abrogate or nullify 370. The procedure has to be still applied. Suppose 367 had been amended in terms of 371(1)(d), 371(d) with the concurrence of the state government. Second step, the Legislative Assembly had made a recommendation, please abandon or abrogate 370. It would have passed muster. Nobody would have really, probably the other side wouldn't have been here also, except some of them.
Yeah, they would still be here, but that's that's beside the point.
But it could have been done. If this route is permissible or not.
I'm putting a question to myself. Suppose
I thought I answered it in your favor.
Your Lordships are absolutely right. That's my answer, my lord. That's my answer. I'm grateful to your Lordship, my lord, for that. That thought didn't occur to me. But suppose we took the decision that in view of the proviso becoming otious, because there is no constituent assembly, that limitation of recommendation, ultimately it's recommendation. Suppose it recommends that don't abrogate. President is not bound by it. So now the Constituent Assembly, having chosen while being dissolved not to recommend, the Constituent Assembly has left it to the absolute discretion of the President. It could have been done, but possibly it could have been defendable action, but with a view to ensure that there is democratization of the action. And my lord, your Lordships are dealing with the state of, this is a provision which is one of its kind. There is no such provision either in our constitution or in any constitution. So the law which your Lordships would ultimately lay down is not going to touch upon any other provision. If suppose the Constituent Assembly, while it was being dissolved, it framed the constitution, it had options. A, don't abolish. I am recommending that President should not exercise powers under sub-article 3. He should not abrogate 370. That was the first option. Second option, he should abrogate article 370 after 5 years. Till then, let the constitution continue. Third, the President is, we recommend that President should modify some of the provisions which we recommend and continue 370 as it is forever. Having done nothing of this, the Constituent Assembly goes without making any recommendation and therefore leaving it to the absolute discretion of the President.
The solicitor, you said that the President is recommendation.
It's a recommendation, my lord. It's not.
You see the words used in the proviso. Provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary.
Yes, Lord. Why I say this, Lord, kindly see the second proviso. There, concurrence word is used. Concurrence means I have to say yes, otherwise you cannot do it. Therefore, I am contrasting the word concurrence with recommendation. Consultation, yes, the concurrence is at the highest level. That without consent, concurrence means consent. Consultation may sometimes mean consent, may not mean consent. Your Lordship has seen Justice S.H. State's transfer of judge's judgment, where it says that consultation can even mean concurrence. So I am not just contrasting the word concurrence with recommendation, that the same provision uses the word concurrence, means unless the state say yes, President can do nothing. But here same provision uses the word recommendation, that you will recommend. Ultimate power with the President who is answerable to the House which is answerable to we the people of India. So highest executive functionary is conferred with this decision, and we can read that in absence of Constituent Assembly and its recommendation, the proviso goes. It becomes redundant, it becomes otious, it becomes not possible of being implemented, and law doesn't require performance of an impossibility. But considering the nature of the strategic importance of the state, it was felt necessary that let this be debated in both the houses of parliament. And Rajya Sabha is, my lord, house of people. It has its own federal structure. Every state has a representation in a different indirect election form. And both houses passes, my lord, with 2/3 majority. Lord, even Constituent Assembly could have recommended that word temporary be deleted. Even clause 3 be deleted. Why not? There was no embargo. During the subsistence, during their existence, and while being dissolved, or during that period, they could have said that delete temporary provision, delete Article 3. Now we don't want anybody's power to abrogate. They could have said even C can be deleted. Suppose, my lord, the Constituent Assembly were to say that delete 1C, that Article 1 is untouchable. Because now we have our own constitution, we no longer are a part of, integral part of India. My lord, it could have said, technically it could have said that. Section 3 of the Constitution says, no, we are an integral part of India. They never said that President's power under 3, we recommend being either diluted or taken away. They never wanted clause 3 to die. That's very clear.
All right. So we've covered now the first point, the interpretation of 370.
My lord, 370, my lord, there are some points. My lord, if your lordship permits.
So on 370, Mr. Solicitor, why don't you summarize in 3 or 4 propositions what's the heart of your submission?
Can I, my lord, do one thing if your lordship permits? My lord, I knew, my lord, I'll be running against time. My lord, instead of, my lord, my 40-50 pages of, my lord, explanation and arguments, I have summarized in 4 pages.
Right.
That would, my lord, save your lordship's time also in, my lord.
So you have it here?
If I can be permitted, my lord, I'll just quickly go through.
5 minutes and we are done with it.
Yes. You can. Says, my lord, it declares it to be temporary. Your lordships may not read anything, my lord. It is contained in part 21, which has 3 categories: temporary, special provisions, and transitory provisions. So constitutional framers are aware of what word they are using. My lord, second, I have said, my lord, I have already said, and this is, my lord, something very, very serious. Look at the width of the power. 2 individuals in practice, and legally speaking, 2 organs, namely the president and the state government, can alter any part of the constitution and apply it to one part, can delete any constitutional provision, can create a new provision, and therefore, my lord, the submission is, considering the very expanse of this provision, the constituent framers would never have, my lord, contemplated this to remain forever. Such a position can never remain forever, where our constitution remains a floating document perennially for one state. Then 3, impact of Article 370 was to deprive the residents of Jammu, Kashmir and Ladakh from being treated at par with their fellow citizens. My lord, therefore, my lord, I am saying that this also is one suggestive indication that framers never intended it to be permanent. Then, Lord, this is the entire provision. Lord, this is very important. This is the entire provision in the Constitution where application of not only Constitution, please see this, my lord, the seriousness of this. Application of Constitution of India and application of central laws, including beneficial legislations, is dependent upon concurrence of the state. The only provision. It says it would not apply, it will not apply. such a, my lord, drastic provision could never have been intended to remain permanently. Then, my lord, this is the only provision which has an inbuilt self-extinguishing provision, sub-article 3. No other constitution provision has this self-destructing clause. This again, my lord, is a pointer that it was intended to be temporary. Then, it is a goal of equivalence, my lord. I have already said, my lord, in the judgment which I read, that temporary problem, my lord, provision cannot be read so as to treat one part of state differently, their citizens differently. Then, my lord, your lordships would not give interpretation to a temporary constitutional provision having such drastic consequences. Because your lordships are not going to be confronted with a similar situation in future. There is no other provision in the constitution. And to our knowledge, any other part of the world where a provision of a constitution of the main unit applies only with the state consents. In a federation like ours, there cannot be any such provisions. My lord, then I have said, my lord, kindly examine it from the people's angle. Then 370 is interpreted the way petitioners interpret. 371 would become permanent, which is not only impermissible and not envisaged, but would result in the unconstitutional provision remaining in the constitution and operating. But unconstitutional, why? It discriminates. It confers an authority which is never contemplated in other states. The application of the Constitution of India given by we the people would either not apply fully or would apply. My lord, I am on 10, point number 10. My lord, I would request if your lordships can read with me. My lord. The petitioner's assertion that such a huge decision is taken purely by an executive fiat is absolutely wrong. The process followed clearly reflects participation of entire nation through their chosen representatives, both in Lok Sabha and Rajya Sabha. When a decision becomes concerns a federating unit, it is of strategic significance, what I have pointed out. My lord, then 13, my lord, is most important, my lord. Sub-article 3. The proviso to sub-article 3 was to remain in operation. My lord, I have already said these are the 5 possible recommendations that Constituent Assembly could have given. The lordships have seen that. Then, my lord, B. Once the Jammu and Kashmir Constituent Assembly ceased to exist, the proviso to Article 370 sub-article 3 itself ceases to exist, and the President becomes the sole repository of power under Article 370 sub-article 3, which is coupled with his duty to exercise in the interest of residents of Jammu and Kashmir without any recommendation. It is for this reason that power is conferred upon the highest political executive, who is responsible to the Parliament, who in turn is responsible to we the people of India. It is thus clear that Parliament, while framing the proviso, merely gave an option to the Constituent Assembly to make recommendation till its life. But 15 is important. This is how the petitioners want your lordships to read. Notwithstanding anything in the foregoing provisions of this article, on the recommendation of the Constituent Assembly of the state referred to in clause B, the President may, by public notification, declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications. The very purpose that the concept of recommendation is provided in the proviso leads to an inevitable conclusion that they wanted it to leave it an option to the Constituent Assembly during its life to make some recommendation. Otherwise, that proviso goes.
According to you, the proviso will not govern the substantive provision.
Cannot govern. Yes, my lords are right. I am obliged, my lord. If the proviso become otiose, the main provision does not become otiose. Then the conditionality attached goes. Tail cannot recognize. Yes, my learned friend is right. If this interpretation to Article 373 is not accepted, and the President's power is under Article 373 is taken away merely because the Constituent Assembly has ceased to exist without making any recommendation, it would create a devastating situation which could never have been envisaged by the framers of the Constitution nor ever been conceived. If the President cannot exercise the powers under Clause 3, it would mean that existence and exercise of power of the President of India provided for in the Constitution is dependent upon some decision or lack of it by a different body. Can we read a Constitution that President's decision is dependent upon some outside body takes a decision or does not take the decision? If it takes, it's an option. If it doesn't take, you lost your option. The President of India cannot be denuded of its power by either they giving recommendation or at least not in absence of recommendation. Such an interpretation would never be given, as such contingency could never have been conceived. Then 17. Secondly, if mere absence of Constituent Assembly mentioned in the proviso to Clause 3 is treated to be rendering the power of President of India nugatory, redundant, and unexercisable, it would mean that by using any provision under Article 371B and 1D, any provision of the Constitution can be amended and applied to the state of Jammu and Kashmir, and even the provisions which are part of basic structure, please mark this, my lord, this is what fell from my lord Justice called, that you are putting it at the higher threshold than the basic structure. Basic structure cannot be altered by constitutional amendment, but there is no such limitation in 1D. You can, they have chosen not to apply some of the fundamental rights, meaning thereby a permanent power is vested on two organs of the state to alter even the basic structure so far as its application to the state of Jammu and Kashmir is concerned. And this is very, very serious. Now, of course, my lord, it can never be done. Now, all are at par. Even if the Constituent Assembly would have been in existence, the limited role stipulated, my lord, that I have already said, my lord, it is only recommendatory, and my lord, President could have taken any other decision.
That may not be correct actually, because so long as the Constituent Assembly, it was not recommendatory. Look at the way the article is couched. Provided that the recommendation of the Constituent Assembly of the state shall be necessary. So it's not recommendatory in that sense.
Our constitution always, let's put it very, constitution as a supreme document in a democratic country will always face restrictions, whether it's the judiciary, whether it's the president, whether it's the legislature.
Lord, I bow down, but my submission.
Constitution is governance by limitation. With limitation.
And the use of the words recommendation shall be necessary is a clear indication that it's not merely recommendatory, but that there has to be a recommendation before you exercise.
Can your lordships read it a slight differently, the way, my lord, I read it? What is mandatory, the word shall, that you take recommendation. The recommendation is not binding, my lord. Otherwise, the Constitution would have said that it would and act accordingly. What is mandatory is taking the recommendation. That's another way of, my lord, interpreting.
So the other part of the argument, we understand that the proviso, after the Constituent Assembly had done its job, is no longer applicable, but it doesn't affect the main part. Main clause 3, we'll examine that out.
Yes. Now 19. The only constitutionally compliant way of interpreting Article 370 to achieve the ultimate goal of bringing the people of Jammu and Kashmir at par with the rest of the country and conferring them with all constitutional and statutory rights at par with the rest of the country is to either read an unfettered and plenary power of the President of India under Article 370 sub-Article 3 once the Constituent Assembly ceases to exist. Just now, Lord, I pointed that out. Or modifying the 370 sub-Article 3 by replacing the successor body. We went for the second, which according to me was not necessary. It could have been done without, my lord, any recommendation also. then power of the President under sub-article 3 is unfettered, as Article 370 starts with a non-obstante clause, notwithstanding anything contained in the Constitution of India, and sub-article 3 starts with a non-obstante clause, notwithstanding anything in the foregoing provisions of this article. But kindly see this, something that might throw some light on the first discussion which my lords, the Chief Justice, very enlightened discussion. 370 starts with a non-obstante clause. Nothing in this constitution, this is how the 370 would function. 370 sub-article 3 starts with a non-obstante clause, notwithstanding anything in the foregoing paragraphs, meaning thereby even 370 can be subjected to 370 sub-article 3. Kindly read it once again. I do not know.
Obviously, because 370 clause 3 has a non-obstante clause which overrides everything else in this in this
Even
article.
1D.
Right.
Even 1D, which says that don't do anything except 1 and 3. And
there are two non-obstante clauses. The first is notwithstanding anything in this constitution. And 370 clause 3 says notwithstanding anything in this article. Therefore, it overrides, therefore, it's a power to override even clause 1.
Clause 1, yes. Clause 1, 2, 2 doesn't come. 1D also. Your Lordship's very illuminating.
But there can't be any doubt about it, because when 370 clause 3 says notwithstanding anything in this article, that would include clause 1. There's no
meaning thereby, modification in 370 itself was permissible through 367.
And when you override clause 1, the plain intent therefore is that the constitution itself becomes applicable then.
Okay.
Once you exercise the power under 3, whether there was a valid exercise is what we have to decide. But once you exercise validly the power under 3, then the constitution applies. That would be the plain consequence of it.
Your Lordship may treat this as read.
Yes, we'll read it. Let's go now to the last point.
Only
last reorganization is
last two pages. The status of Constituent Assembly. What was the status of Constituent Assembly? Because nomenclature is a Constituent Assembly, but whether it enjoys, I am at the outset.
You are saying that it is subordinate to the Constituent Assembly for the Union. I mean, you can't elevate that Constituent Assembly.
I must clarify one thing as an officer of the court. But I am conscious of the principle laid down in Keshwanand Bharti, that there is a distinction between Constituent Assembly and Parliament. And Parliament, or Constituent Assembly and Legislature. They are not interchangeable. That's why, my lord, this submission, that here Constituent Assembly for all intent and purpose was a legislative assembly, not preparing a document of governance for a sovereign region, but was, my lord, kindly see, my lord, there are some arguments based on my lord, the judgment also, my lord. But the position as far as the state of Jammu and Kashmir is concerned, even prior to coming into force of Article 1, was who created Constituent Assembly? The Maharaja, who signed instrument of accession and surrendered his sovereignty. Then he issued that proclamation. Your Lordships are, my lord, remembering that now whatever constitution is framed would be binding on it. He subsequently, my lord, creates a Constituent Assembly. So he could never have created a Constituent Assembly which would have a role independent of, larger than, or completely different from the Constituent Assembly of which he became an integral part. And at that time, my lord, the Jammu and Kashmir was an integral part of India. So the body which was created was known as Constituent Assembly, but was a subordinate creature, then, my lord, Constituent Assembly. And the Constitution of Jammu and Kashmir can never be put at the same pedestal as the Constitution of India, because the very birth of the Constituent Assembly of Jammu and Kashmir was because of Article 370. And
in other words, according to you, the role of the Constituent Assembly of Jammu and Kashmir is the role which is created for it by our constitution, by the
Yes.
Constitution of India,
Of
nothing
India.
beyond that.
It cannot be beyond that, above that, or superior to that. It is subservient and subordinate. It never had original constituent power. Lord, please see, Lord, the constitution as we understand around the world, Lord, has certain attributes. Namely, it must be a document of governance, providing for everything the way, my lord, we have provided. This constitution has only certain aspects. Rest, my lord, they leave it to the Constitution of India. For being recognized as a constitution, you must provide for a kind of sovereignty. I'm not on, my lord, sovereignty means sovereignty, my lord, it's not autonomy. And sovereignty would mean right to acquire new areas and right to cede new areas, right to acquire territory and right to cede territories, which we have in Article 1, 2, 3, 4. Constitution of India has. Lord, none of the attributes of a constitution, so to say, Lord, can be attached to this constitution. It was a piece of legislature recognized, accepted, and known till 5th of August and 6th of August 2019 as constitution. But for all intent and purposes, my lord, it was, my lord, even the preamble of the constitution doesn't say so. A preamble of constitution of Jammu and Kashmir doesn't say so, that this is a document which is a constitution. It merely says, Lord, please see the constitution, the preamble of Jammu and Kashmir constitution. It says, with a view to further define our relationship with Union of India. It doesn't say that we are creating a constitution of our governance. So please see, that's the only purpose. They say, we the people of Jammu and Kashmir, with a view to, I'll just read for your lordship, my lord. Lord, I'll just read, my lord. It is, kindly note the page. Volume 2, page 16. Your lordship need not open, I'll just read. Even preamble doesn't say that it has attributes of a constitution per se. We the people of the state of Jammu and Kashmir.
Sir, Solicitor, there is another more fundamental reason why your argument may be correct, which is this. Look at section 5 of the J&K Constitution. It says the executive and legislative power of the state extends to all matters except those with respect to which Parliament has the power to make laws for the state under the provisions of the Constitution of India. So once the Constitution of India defines which is the area in respect of which Parliament has the power to make laws, then that is denuded from the jurisdiction of the Jammu and Kashmir Legislative Assembly. Now we have seen how progressively the ambit of the legislative domain of Parliament was expanded. For instance, initially the entire concurrent list was outside the power of Parliament.
Correct.
You had only certain entries in list 1, the union list.
I am obliging.
Right? Subsequently, the concurrent list was brought in. Once the concurrent list is brought in within the domain of Parliament, to that extent, the legislative domain of the Jammu and Kashmir Legislative Assembly is denuded. Then entry 97 was wholly outside the purview of Parliament initially. Later on, as we see, entry 97 is also gradually brought in within the purview of Parliament, albeit in the context of laws affecting the sovereignty and integrity of India,
some subject,
terrorism, so on and so forth. Therefore, it's very obvious from section 5 of the J&K Constitution that once the Constitution of India prescribes a certain legislative domain for Parliament, then that is progressively denuded from the legislative ambit of the J&K Legislative Assembly. And that was not fixed as of 1957. Another very important feature is that section 5 does not fix the ambit of the legislative or executive domain of the J&K government and the Legislative Assembly as of 26th of January 1957.
Correct.
In fact, it contemplates that what the Constitution of India will prescribe for Parliament will be outside the domain of the
of our domain.
So in that sense, it is always intended to be subservient to the Constitution of India.
And my lord,
it's not really a document which has
Section
equivalent
cannot.
effect.
And And that's what the 147 makes these provisions unamendable. Section 147.
Section 147.
3 and 5 cannot be amended. Otherwise, what happens? Lord, this is amendable. This constitution, if it would have survived, was amendable by the legislative assembly. So they can amend their preamble and academically, potentially, can become a theocratic state because secularism was not applicable.
All right, Mr. Solicitor, I think we've gone through your Article
Yes.
370 note. Now, what your Constituent Assembly note? Now, what's
My lord,
about?
now, my lord, my
Now you have to deal with the important part about states reorganization and the conversion of
yes, my lord.
the state into a UT. How do you answer that?
My lord, I'll take a little time on this one, not unrealistic time, but there are 3-4 judgments, my lord, which are direct judgments.
All right.
But your lordships would bear in mind the difference between our constitution and say Constitution of America, where there is a contract between the state and the federal government, and that is how they formed the United States. The federal government doesn't have the power to even alter the boundaries of the states because it's a different and distinct.
There was no contract between the states and the federal government in the US. The
Internal,
13 colonies came together to form a union,
to form.
and
You
they
cannot be
surrendered
correct.
some
I
powers
stand
to
correct.
and they surrendered some powers to the union.
To the union. Otherwise, retaining, my lord, some of the states have its own Supreme Court, etc. My lord, whenever, my lord, a nation like ours and the federalism which we have accepted, which is, my lord, kind of leaning towards unitary feature. I'm not arguing on that unitary versus federalism. But at times, the nation requires to rejudge the boundaries and the status of their states. But there are several considerations. And therefore, at the outset, my lord, I may point out that this is a case, one of its type, which is not to be encountered, my lord, by the court. For example, if Gujarat was to be bifurcated or Madhya Pradesh was to be bifurcated, the parameters would be different. But when Jammu and Kashmir, considering its very strategic importance, border state, history of terrorism, history of infiltrations, history of outside influence, outside means outside the country, etc., etc. There would be several considerations in the mind of the government. We share border with 4 at least countries, all of which may not be friendly, not to put it mildly. That's what I say.
Argument based on border states is a problem. We have many states on the border.
No, history also. The history, I have given the details in my affidavit, filed long back, how the situation in Kashmir is developing. The number of deaths of civilians, the number of deaths of security forces, the number of attacks, the number of stone pelting, the number of every week 2 or 3 days of hartal, paralyzing schools, hospitals, banks, business houses, everything. All these are policy considerations. Whenever a state reorganization takes place, not only there are policy considerations as to why the state needs to be reorganized, but there is always a blueprint as to what the central government would do after the state is reorganized. How to bring, in a peculiar facts of this case, the youth in the mainstream, how to ensure that they are gainfully employed, how to float certain schemes so that people on the bordering or who are continuous facing the attacks of shelling, etc., are now getting a sense of confidence that the government has not left us, etc. There are several considerations that we will have to start with, say, democratic local self-government elections so that the people participate in the internal local self-government institutions for their own good.
The source of the power to reorganize, which is with the Union of India, is the same.
3 and 4.
Right?
Parameters would differ.
But therefore, A, do you concede that power to the union in respect of every Indian state? You're not saying that you should concede that no, this only exists for J&K, it exists for every Indian state. Right?
The power is for all.
Once you concede that power to the union in relation to every Indian state, how do you ensure that the kind of abuse that they apprehended? We are now not defining it for today, but what we lay down would be the law for the last.
But I
It
had
is revised by some larger bench at some point of time. But how do you ensure then that this power will not be
used, my lord, in case of others? My lord, that was my worry. I share your lordship's worry, and therefore, my lord, I started by saying that your lordships are dealing with a one of its kind situation, which is not going to arise, my lord. And if, my lord, I point out, my lord, after
Not one of its kind situation. We have seen on the northern border, Punjab, very difficult times. Similarly, some states at different times in northeast, all border states.
One of the states in northeast presently.
Many
none of
times
them.
as because of whatever reasons, near the border, we can't choose our neighbors, as they often say. We have had problems.
Correct.
So the worry which Chief Justice expresses is that tomorrow, if there is a scenario of order, can each of these states face this problem?
And why each of these states only, my lord? It can happen to, for example, Madhya Pradesh or Gujarat or any state.
Your argument from the borders is what I am testing. See, there are states which are on border of other countries where situation may not be very palatable. Now, at least those border states, I understood your argument that these border states are category by themselves. How do we distinguish between Jammu and Kashmir and any other border state?
I'll just, I'm grateful, but I'll point out. Lord, in none of the border states, take Lord, northeastern states or Punjab, as your lordships gave an example.
border state?
Northeastern states or Punjab or any other. Rajasthan has a border, Gujarat has a border.
What possibly is being pointed out, you can't say because it's a border state, so it has to be treated.
I'm not saying it, my lord, that's not the distinction I'm drawing.
Because then it's a very, it'll
Yeah,
be.
my lord, there are several border states, Gujarat, Rajasthan,
Himachal, Uttarakhand.
Uttarakhand, Himachal. I'm not, my lord, kindly don't misunderstand my submission that because it is a border state, it requires different treatment. My lord, kindly see the consistent, repeated situation which we are facing since decades on a daily basis is not happening in Gujarat or Northeast or any other border state. Here is a border state where one of our territory is occupied by Pakistan, or we have POK. I have given figures. What are the deaths taking place every year, right from 20 years before? This is a problem faced by the nation from decades, since decades, which we are, my lord, trying to, my lord, sort out or deal with. And I'll show, my lord, this is not, my lord, just, these decisions are never taken as knee-jerk reactions. There is always, my lord, policy considerations. Border state, this particular state being a different kind of a border state is one, but there are several considerations. And one of the consideration would be how to bring the youth in the mainstream. And I'll point out, my lord, everything was kept in mind and is implemented. And what we are seeing today is the result of that blueprint being implemented. My lord, after this decision, there were elections which took place of district development councils. There are 34,000 elected people. Democracy going to the grassroots. There are large number of schemes which are introduced. The youth which used to be employed by the interest, not inimical to India, maybe terror groups or whoever, and were paid now are gainfully employed. You know, there is always a blueprint, and I'll be able to show that blueprint working. Lord, I'm not conscious of the fact that end would not justify the means, but end, your lordships can certainly see whether these policy considerations which decided the reorganization were correct or not. Because the government has acted with a blueprint, not only for reorganization, what would be done after reorganization and how Jammu and Kashmir would return to normalcy. And I'll be able to show the steps which are taken. Right now, my lord, I will deal with in three parts. My lord, the impression which is given to your lordship is that this has been reduced from state to union territory. Means there is a downgradation. And my lord, there are some other factually incorrect statements were made, my lord, by one of the council, my lord, who argued for reorganization, against reorganization, that we lost this, there is no representation, there is no consolidated fund of India, we can't participate in election of president, our seats in the parliament is gone.
Let's look at it at the first level, basic level, the textual level of the constitution. Let's go step by step. Then we'll go to the last part, namely, which was what motivated this decision. And there you have said that these are policy considerations. Look at the nature of the state, the history. You can't lose sight of all that. We must also deal with it at a textual level. Does Parliament have the power to convert an existing Indian state into a union territory?
Yes.
If it does have that power, how do you read Article 3? If you can just assist us on, that's the basic textual question.
Yes, Lord, there are, my lord, specific judicial pronouncements on.
No, but we will go to the judicial pronouncements.
I'll
Why don't you
actually
first look at the text in the statute?
Before that,
of the Constitution.
may I request your lordships to have a just bird's eye view of the Reorganization Act itself? No one has shown that, my lord, to your lordships. I want your lordships to see that.
We look at the Reorganization Act. That will provide us.
I'm not reading every part. I'm just taking your lordship through the titles. Lord, nobody has read, my lord. And
First, that's worrying us. Let's look at the source of the power.
Kindly come to, my lord, Article 3.
Just in a minute or so.
Yes.
Just how you interpret
Article 3. Article 3.
Also, I would like to know whether it's some kind of a, what is the nature of exercise of that power? Is it a permanent exercise of power? Is it a temporary exercise of power? What is
No,
that?
it is, my lord. I must, Lord, let me answer that straight. Lord, this question was put in the parliament when the reorganization bill was passed. Lord, I'll just read, my lord, the statement of the honorable minister on the floor of the house.
So the union territory here is not intended to be a permanent territory.
No, my lord.
All right.
And that's what, my lord, I'm making.
Question number two.
Yes.
How impermanent is it? And question number 3, when are we going to have elections?
I understand, my lord. So that is why, my lord, I was going to show to your lordships the steps taken to ensure that we reach that stage. I will show those steps.
All right. Now let's go to Article 3.
Article 3. Article 3. Formation of new states and alteration of areas, boundaries, or names of existing states. Lord, first, my lord, before that, please read, my lord, explanation 1 so that your lordships can read in that context. In this article, in clause A to E, state includes a union territory, but in the proviso, state does not include a union territory. Correct, my lords?
So wherever you read state, read union territory.
Union territory except the proviso.
So now let's read clause A in
Yes.
the light of that.
Yes, and my lord, this very reorganization has been subjected, and my lord, this honorable court has said that it is permissible. This reorganization act has passed the muster of your lordships under 3 and 4. The judgment I will show. Parliament may by law form a new state by separation of territory from any state or by uniting 2 or more states or parts of states or by uniting any territory to a part of any state. So, my lord, I would read, Parliament may by law form a new union territory by separation of territory from any state or by uniting two or more states, we are not concerned, or parts of the state, again, we are not concerned. So there is a power of having two union territories out of one state. Then B, increase the area of any state, diminish the area of any state, alter the boundaries of any state. But here, this would also result.
Does clause A contemplate a situation when the entirety of a state can become a union territory?
There are two, Jammu and Kashmir and Ladakh. There is nothing, my lord, which
Does
prohibits.
clause A contemplate a situation where an entirety of a state can become, say, more than one union territory? What you have done?
It can, my lord. I am not answering that question because that doesn't arise here.
Your argument is that because of explanation, we will have to read union territory.
Yes.
In
And,
clause one.
and in a given case, my lord, I don't want to pitch that high.
Clause A, the problem. Form a new union territory, we will not read it as state. Form a new union territory, singular will include a plural. So form more than one union territory, no problem. Form a new union territory by doing what?
By separation of territory from any state. Territory means geographical area.
Right. So from the state of J&K, you carve out a territory and form, say, a union territory of Ladakh.
Jammu, Kashmir and Ladakh. But I don't want to, my lord, pitch that high. But otherwise, it would not prohibit even a state being made union territory. But that's not the question we are dealing with, my lord.
So the first part of clause A, in other words, according to you, form a new union territory by separation of territory from any state.
And
We
singular,
contemplate a situation where you have a larger state and you contemplate the creation of a union territory by separating out a territory. In this case, you separated out a territory to form the union territory of Ladakh, and then the remaining you carved out and said this will be the union territory of.
It will not amount to reading. Suppose you had not carved out Ladakh and you had declared the whole thing as a UT.
there is no restriction in doing that. I don't wish to pitch it that high.
You want to test and understand. Suppose you create one UT only. Then it is form a new state by separation of territory from any state. That has not occurred. No UT has been carved out. Or by uniting two or more states or part of the state, or by uniting any of the territory into part of the state.
By separation.
How will it apply? Suppose you had not carved out Ladakh.
Possibly,
The whole
possibly.
state. So then the power would be the conversion of any state into a UT.
That possibly
The
is.
fact that you carve out a part of a state.
Possibly, your lordships are right. That is not.
Higher, this thing.
That is possibly not contemplated, subject to. But form a new state, that is form a new union territory
That's the proposition. to
by
discuss.
separation of territory from any state. So separation is necessary.
So if you don't separate and create, you really, how do you contemplate converting a state into UT? And if, I'm just saying for the sake of argument, if that is not possible, can you do that by carving out the UT and making the other also UT?
There is no restrictions. And this is how, my lord, it is understood by your lordships also. Because, for example, my lord, Assam, Tripura, and Arunachal became UT first, and thereafter became state. Assam remained a state, that's the distinction. But Assam could have also become a UT. There is no restriction.
That's what I'm saying. See, just carving out Ladakh as a UT is, I would say, less complicated in its nature. So therefore, to test the proposition, I am saying, suppose you don't carve out Ladakh, you decide that the whole state should be a UT. So can you do that and say J&K state will remain as it is as boundary, but from state it becomes a UT? When we want it, we'll reconvert it back to the state.
My lord, my first reading is separation is necessary. That's my first reading.
That is what is a little.
Because that question we are not faced, my lord, right now in this.
a question will arise to test it that if you cannot convert a state into a UT, then can you carve out a UT? Just fine. But in the bargain also say that what I could not do without carving out a UT, I can do it now by making both of them the UT.
No, because I had a separate reason to carve out Ladakh as a separate UT.
You wait, no difficulty. That's your decision. That's why I'm saying this less complicated
Yes.
by its nature. Carving out a UT.
Here it's less complicated.
Reducing both parts of the carved out and the pre-carved out. So suppose Assam you carved out a UT, but you say no, we carve out a portion of the Assam as UT and also convert Assam into a UT. That's the testing proposition.
It would be an extreme example, but for the purpose of testing, there can be two answers. A, separation would be necessary, and if separation takes place, that doesn't take place if one state is declared UT. So one state cannot be declared.
What is troubling me? Whether
Your Lordships are right. One state possibly, under 3 cannot be declared as UT. But here, it is nobody's case that we declared Ladakh as UT to come out of this embargo. It's nobody's case. We had separate reasons.
Mr. Solicitor, there may be another way of looking at it. Apropos the theme with which you began, which is the general situation in Jammu and Kashmir. As we see, the creation of union territories post-independence, you have on the one hand examples like Chandigarh, which was carved out during the Punjab Reorganization Act and remained a union territory. It is a permanent union territory.
It was a part of state.
It was a part of a state and became a union territory to be the common capital for two sister states. That one. Then you have a progression where certain areas of existing states became union territories in the progression of making them states. That's the Northeast. For instance, you have Mizoram, you have Manipur, you have Tripura. They were part of states. They become union territories, but that's in the process of making them into a stable administration to become states. You can't immediately make them states. Parliament can certainly make that. But today, the situation is not right to make them full-fledged states. Today, we will carve them out, give them the status of a union territory at a future point of time when Parliament feels that, well, they now are sufficiently stable institutionally, we will make them as states, which we did in the Northeast. Put something, perhaps you may look at what we are trying to suggest. Why is it not possible for the union to say that, well, right now, say in a case of a particular state, we have such an extreme situation in terms of national security, in terms of, other...
We want direct control.
That we want for a certain stipulated period that a union territory should be created. But this creation of a union territory is not a feature of permanence. But this shall then again progress back to its position of a state.
Removing the reasons why it was required to be converted.
The union not have a control for a certain stipulated period to bring stability, because ultimately, let's face it, whether it's a state, whether it's a union territory, all of us have survived, the nation survives.
Yes.
Right?
Doubtlessly.
If the nation itself doesn't survive, there's no question, there's no relevance of states or union territories. So is it not should we not give that allowance to Parliament to sort of postulate that for a certain period, in the interest of the preservation of the nation itself, in the interest of the preservation of the union itself, we want for a certain stipulated period that this particular state should go into the fold of union territory on the clear understanding that this shall revert to a position of a state over a period of time. You can't lay down that period in a given case. In a given case, it may be 6 months. In a given case, it may be 1 year. But that progression, I think the government has to also make a statement before us. Look, that progression back to a state has to take place. It can't be a union territory in permanence.
I'm grateful, Malad. That's exactly, I'll read, Malad, after the lunch. That's exactly the statement made on the floor of the House. I'll read, Malad, that statement. That this is not a permanent feature. After the situation returns to normalcy, we want it to become a state again. I'll read, Malad, that statement.
And then after lunch, we would also have we don't want to bind you down to because we are conscious of the fact that these are matters of national security. We understand that, ultimately the preservation of the nation itself is the overriding concern. But without putting you in a sense of a bind, both you and attorney may seek instructions at the highest level. Is there some time frame in view?
No time frame. I'll take instructions once followed from your lordships, but I'll show the statement made on the floor and the efforts made. And the statement is, once the efforts are fruitful and everything is normal, then, my lord, there is a. But I'll
equally, Mr. Solicitor and Mr. Attorney, restoration of democracy is a very important.
Absolutely,
it's a vital
but
component for our nation.
In 2020,
have a situation where you have.
But not only one thing, but give me a second more. In 2020, for the first time in the history, the local government elections took place. 34,000 people are now elected people, which is possible only because of.
Therefore, the progression, we take your point. We take your point that the progression has already begun.
Yes, no hartal, no stone pelting, no curfew. At least situation is normal.
But
no, I am not only on election and politics. I am on national integrity.
Is there a roadmap?
Yes, it is.
And tell us what the roadmap is.